Hello, everyone, and welcome to Uncivil Law. For today's case, we have Cambridge Christian School versus the Florida High School Athletic Association. In this case, two Christian schools were playing a football game. The game, however, was administered by the Florida High School Athletic Association, which is a government entity. The two Christian schools wanted to have a prayer over the broadcast system as part of the game. The Florida High School Athletic Association, however, said that this would be improper state action as it relates to establishment of religion. The Court of Appeals thinks that there's not enough factual record to decide this, and so I thought it would be a really interesting case to show some interaction between private action and state action when it relates to religious issues. So let's read this case and see what happened. At the end of the 2015 high school football season, Cambridge Christian School and University Christian School faced off in the football game. The two schools, both Christian institutions, asked the institution that was doing it for permission to conduct a joint prayer. The FHSAA denied the request, citing the separation of church and state. Cambridge Christian brought this law school in federal district court, raising a variety of claims, primarily free speech and free exercise. The trial court dismissed the entirety of the complaint for failure to state a claim. For starters, it concluded on the free speech claims that all the speech over the loudspeaker was governmental speech, and therefore the school enjoyed no expressive freedom in the medium. In the alternative, the court determined the loudspeaker was a non-public forum and that Cambridge Christian was not entitled to access. As for the free speech clause, the court held the school's free exercise rights had not been implicated when the institution denied access because the teams were still allowed to pray at the center of the football field, albeit without the aid of the loudspeaker. As we see it, the district court was too quick to dismiss the claims. There are too many open factual questions for us to say with confidence the allegations cannot be proved as a matter of law. The question is whether all speech over the microphone was governmental speech. It's a heavily fact-intensive one that looks at the history of the government's use of the medium for communicative purposes, the implication of government endorsement over the messages, and the degree of government control over the message. Here, the history factor weighs against the government speech, and the control factor is intermediate, so based on this limited record, we find it plausible that the multitude of messages delivered out of the loudspeaker should be viewed as private and not governmental speech. And while we agree with the district court that the loudspeaker was a non-public forum, we conclude that Cambridge Christian has plausibly alleged it was arbitrarily and haphazardly denied to the forum. So a couple things here. The first question is whether or not this is governmental speech or private speech. If it's governmental speech, then government gets the right to control its own message, and the government is barred from engaging in religious shows of proselytization, for example. Here, the court is saying that's unclear on the record because the medium seems to have been used for both kinds of speech, and so it's unclear that it could be viewed as governmental speech. And it's also saying that there's unclear on the record as opposed to the discrimination, so it's sending it back for further findings. Cambridge Christian football team plays in Division 2A, which is supervised and regulated by Florida's High School Athletic Association. The association is the governing nonprofit organization of high school athletics. It is so designated by the Florida legislature in 1997, and because of the statutory delegation of authority, is a state actor. It includes over 800 member high schools throughout Florida, many of which are private and religious in nature. In 3 earlier rounds of the playoff, Cambridge Christian was the home team and hosted the games at Skyway Park, a public facility in Tampa owned by the county. Before each of these games, Cambridge Christian apparently was allowed to pray at a loudspeaker at the park. During a December 1st, 2015 conference call 3 days before the game, the representatives of Cambridge Christian and the University Christian, that is both teams, asked to use the loudspeaker at the stadium to lead attendees in a pregame prayer. The university explained it had been allowed by the association to use the loudspeaker prior to a 2012 championship game against a different Christian school. The association responded later that same day and said that they were unable to comply with their request. He explained the facility was a public facility, that they were a state actor, and therefore it could not permit or grant a request for a pregame prayer. Before and after the game, the PA system was used by the association's public address announcer to deliver a variety of messages, including advertisements, commentary, and other communications. At halftime, each team was given 7 minutes for its cheerleading squad to perform. During this time, Cambridge Christian said it was permitted by the association to take control of the loudspeaker in which cheerleading coach used to play music from her smartphone. Putting aside the obvious copyright issues, the fact that advertisements were relayed during this and other non-speech action occurred on the system does seem to undercut the fact that it's purely a governmental speech medium. So there was a mix of both governmental and private use of this medium, and so that does undercut that argument. The association explained that prayer before football games have been richly debated and decided in the courts of the United States. He referenced, unmistakably, but not by name, the Supreme Court's decision in Santa Fe Independent School District versus Doe, which involves exactly this issue, prayer over a loudspeaker during a football game, as being directly on point. It is directly on point, and established precedent preventing the association from granting the request. Doing so, the association explained, would mean the state actor was endorsing or promoting a religion. The email also argued that no one had been prevented from praying. The fact of the matter is both schools involved had prayer on the field both before and after the game. The issue is never whether the prayer could be conducted. The issue was and is that the association, the governmental association, which is deemed to be a state actor, cannot endorse or promote religion. The issue of prayer in and of itself was not denied to anyone in the team or anyone in the stadium. It's simply not legal, permitted under circumstances which were requested. The district court began its analysis by addressing Cambridge Christian's free speech claims. It concluded, based on a review of the complaint, that all communication over the loudspeaker during the championship was governmental speech, thereby eliminating all the free speech claims. But in the alternative, that even if some of the speech over the loudspeaker was private speech, it occurred in a non-public forum where the exclusion of the requested prayer amounted to a permissible content-based regulation. Perhaps of greatest significance, the parties disagree about how we ought to classify and analyze Cambridge Christian's claim under the free speech clause. The association claims that all the speech over the loudspeaker was governmental speech and thus not subject to the provisions of the First Amendment at all. The association argues in the alternative that even if the prayer would have been private speech, the public address system was a non-public forum, which they denied access to. Cambridge Christian argues, however, the public address system was a limited public forum, but the forum analysis is beside the point because the association discriminated against its speech on the basis of its religious viewpoint, which would have been impermissible even in the non-public forum. So we see the two arguments. The government is arguing it's governmental speech and it's permitted, and they're arguing that no, they based it specifically on religious, which they're not allowed to do, and so therefore it was religious-based discrimination. Okay. The district court reached two basic, albeit independent, conclusions. First, it held that all the communications over the loudspeaker was governmental speech. Alternatively, the trial court concluded that even if the public address system was some type of forum for private speech, it was a non-public forum at best, and the restriction was lawful. We, the Court of Appeals, disagree with both conclusions. As we see it, there are simply too many key facts left undetermined at this preliminary stage. It is by now clear that under the First Amendment that if all the speech over the loudspeaker was governmental speech, the case could not proceed under the Free Speech Clause. Taking the facts in the light most favorable to Cambridge Christian, we find a history of private speech, and also that allegations regarding control of speech delivered over the address system paint an unclear picture. Because one of the three key factors towards finding that at least some private speech was disseminated over the address system and the control factor is mixed, we reverse the district court's threshold conclusions that the public address system was used to convey only governmental speech, along with its dismissal of the free speech claims and remand for further exploration of the relevant facts. So the Court of Appeal is, of course, not finding any facts. They're simply saying that the factual record is incomplete. You need to figure out whether this is a governmental speech or it's not. And there seems to be evidence on the factual record that there's some non-governmental speech. So you need to analyze that along with other stuff and figure out whether this is a governmental forum, a private forum, or some sort of mix between the two. And saying, based on the fact we have some evidence here, you dismissed it too fast before there could be a factual finding. And I tend to agree with that. There does seem to be an underdearth of it because it was dismissed on summary judgment, right? So there's no discovery, no trial. So there doesn't seem to be enough evidence to reach this kind of conclusion. And one of the evidence that's on record seems to undercut the conclusion. So this seems to be appropriate for that reason. The first factor, history, asks us to decide whether the type of speech under scrutiny has traditionally communicated messages on behalf of the government. Here, the district court concluded the history factor weighed against finding the speech was governmental speech. We agree because allegations in the complaint strongly suggest the state has allowed dissemination of prayer over the system in the past. Thus, we are satisfied that Cambridge Christian has alleged enough for us to say history plausibly weighs in favor of characterizing the speech over the loudspeaker as being, at least in part, private. The second of the factors, endorsement, asks us whether the kind of speech at issue is often closely identified with the public mind with the government, or somewhat differently, whether observers reasonably believe the government has endorsed the message. While speech disseminated over a loudspeaker at an event is plainly more transient than any of the comparators, for example, states, statues, license plates, or banners, it is tied to the government spatially in the same way banners were tied to the schools and monuments were tied to the city because it occurs at a government-organized event. Just as we assume that owners of property do not generally put up banners or monuments that convey messages with which they disagree, so too we can safely assume the organizers of the sporting event, a league, a home team, or in this case the association, generally would not allow the public address system to be used to convey messages they did not want to be associated with. Cody Sam says, I'm confused by the conclusion. How does it happen before and make it okay? Couldn't it mean it's erroneously occurred in the past? Sure, it could mean that it's erroneously occurred in the past, but it's still something you have to factually analyze because the question is basically the arbitrary and capricious nature of it. The government can't act arbitrarily and capriciously. It can allow it sometimes, not other times. So yes, it could be that they made the mistake before and they're correcting that mistake, but again, that is not clear on the record because there's not been any testimony to that fact. No one testified that we realized that we made a mistake, and so we decided a new policy going forward. And so if that's the case, then that's the case, but we haven't developed the factual record to know whether it's arbitrary or whether it's based on a correction of the past. The types of message conveyed over the loudspeaker also suggest observers would believe government endorsed the message conveyed over the loudspeaker. Advertisements over the public address system might be relevant to any analysis of the endorsement factor, but at this point we don't know much about them. All the complaint tells us is the messages were delivered by the announcer. So exactly how they were labeled and how they were described might be relevant. This is again going to a factual question that's not well developed. Cambridge Christian argues, nevertheless, the endorsement factor weighs strongly in its favor, but that argument is unconvincing. It points to our statement that views do not become state views merely because they're being uttered at a state event on a state platform. But we've said that in an establishment clause case, not a free speech case, and reference to government speech overall, not an analysis of the endorsement factor. It's surely right that views don't become state merely because they're uttered on a state platform, but being uttered on a state platform certainly helps. Finally, the control factor asks whether the relevant government unit maintains direct control over the messages conveyed. The association controlled physical access to the microphone, but notably, whether it controlled content of the speech that went out over the loudspeaker is far from established. Thus, we find nothing in the Administrative Procedures or Participant Manual to indicate whether the association reserved any right to reject a song or musical choice, or participating schools could not play songs with, for example, explicitly religious or political messages. We also don't know what it means to take control of the loudspeaker and whether this entailed access to the microphone. Given the lack of facts as pled, we simply do not know if any limits were in place. So here they're referring to the musical selection that was used during the halftime cheerleading performance. So it's not clear if the government made any sort of decisions on what sort of songs to allow or what sort of routines to allow. And so if a person chose a religiously themed song, would that be allowed to be displayed? And, we don't know. So that goes to a factual issue that needs to be developed. The long and short of it is we simply do not have enough information to say with any confidence that if everything in the complaint is true, speech disseminated over the public address system was and would not have been governmental speech as a matter of law. The history of prayer at past games, as alleged in the complaint, tells the first factor against finding speech presented over the loudspeaker was governmental speech, but the implicit endorsement of messages carried out over the loudspeaker at a state event cuts the other way. If some or all the speech conducted over the loudspeaker at the 2015 championship was not governmental speech, that necessarily means at least some of it was private. Our courts have employed a forum-based approach for assessing restrictions the government seeks to place on the use of its property. This requires us to consider what kind of forum has been created, what restriction on access has been enforced, and whether the restriction was constitutionally permissible. So here it's saying that if there is some ability for the private people to communicate on this forum, that there are standards in terms of what kind of forum it is that the government has to follow based on what kind of opening it has given. The first step in the analysis is to discern the nature of the forum. The association plainly did not create a traditional forum. Traditional forums are things like park streets. They are like long established things. It would be hard to create a traditional forum, but They're long established things. It's obviously not traditional now. We can also say with great confidence that we're not looking at a designated public forum. Designated public forums have to be done with some intentionality, and that's obviously not the case here. They didn't say, yes, this is a public forum, so that's not the present issue. Two options thus remain, what's called a limited public forum or a non-public forum. A limited public forum exists where the government has reserved the forum for certain groups or discussions of certain topics. Finally, a non-public forum is a governmental space that is not by tradition or designation a forum for public communication. A space where the state is acting only as a proprietor managing its internal operations falls into this category. Examples include polling places, mailboxes of public school teachers, terminals and airports, and military bases. Cambridge Christian has not plausibly alleged the association created anything more than a non-public forum. A state actor does not create a public forum, limited or otherwise, by inaction or by permitting limited discourse, but only by intentionally opening a non-traditional forum for public discourse. The extent to which the forum is open and various speakers is relevant for what it suggests. Speech in a non-public forum can be restricted in order to preserve the forum for its intended purposes, communicative or otherwise, as long as the regulation on speech is reasonable and not an effort to suppress expression merely because public officials oppose the speaker's view. The government has much more flexibility to craft rules limiting speech in a non-public forum than in any other kind of forum. But it's equally clear that non-forum status does not mean the government can restrict it in whatever way it likes. Thus, it remains true that even in the non-public forum, any barrier to access must be viewpoint neutral and cannot be exercised in an arbitrary and haphazard manner. Because there is little reason to think from the complaint and the limited record that the association would have allowed prayer from one religious sect but not another, or would have allowed some solemnizing message but would not allow other messages, we think the restriction amounts to a content rather than viewpoint-based discrimination. The email from the association concluded that since the association was a state actor, according to Florida courts as designated by the statute, the organization could not have granted Cambridge Christian's request without running afoul of Santa Fe Independent School District versus Doe, where the Supreme Court held that a public schools district's policy of permitting student-led, student-initiated pairs over a loud system at the start of football games violated the Establishment Clause. Cambridge Christian argues this request was denied because of the religious perspective of its speech, which makes it viewpoint discrimination, but we disagree. The complaint does not allege, for instance, that Christian prayers were prohibited, but Jewish or Muslim prayers which would have been allowed, which would have presented viewpoint-based discrimination. Having concluded the complaint plausibly alleged the forum was likely a non-public one and the FHS and the association's restriction was likely content-based, the final step in our analysis is to examine the restriction for reasonableness. The Supreme Court has made it clear that even in the non-public forum, the government must avoid haphazard and arbitrary enforcement of speech restrictions in order for them to be upheld as reasonable. The complaint has plausibly alleged that the association's prohibition on prayer at the 2015 game had a substantial defect. The restriction was arbitrary and haphazardly applied by the state. So here they're arguing that it was arbitrary and capricious, arguing that the government acted without rhyme or reason, and the government's not allowed to do that. Notably, Cambridge Christian has alleged that two participating teams, University Christian and Day Christian School, were allowed to pray before the 2012 game administered by the association, and that it prayed over the loudspeaker during the first 3 rounds of the 2015 playoffs before the games conducted under the auspices of the association. So other teams were permitted, they were permitted under various times, but they're not permitted now, and nothing really has factually changed, so that does tend to suggest arbitrary and capricious. Permitting certain speech on Monday, Tuesday, Wednesday, and Thursday, and barring precisely the same message on Friday without any credible explanation of what may have changed is the essence of arbitrary, capricious, and haphazard, and therefore unreasonable decision-making. The school's message does not appear to be naturally incompatible with the purposes of the forum. We know that prayers were delivered on 4 prior occasions, presumably without incident. The undefined message may have been presented by the schools, and the schools had considerable leeway in presenting their halftime shows, and at this preliminary stage of litigation, we lack any record of evidence to explain the restriction. The explanation that it wanted to comply with the Establishment Clause and the Supreme Court's decision in Santa Fe might have been reasonable in a vacuum, but it does not explain why the restriction was enforced in an inconsistent manner. So the association is saying, look, we developed this rule because the Supreme Court required us to in this particular case. And that seems perfectly reasonable, but it's not reasonable on the record why it endorsed it some places and not other places. It may be the association simply made a mistake, but because we don't have any factual record or testimony to that effect, we don't know what the basis was. So we don't have a well-developed record to know what the thinking of the government was in terms of its enforcement of the statute. We do not foreclose that a court may later conclude on a fuller record that any message delivered over the loudspeaker was governmental speech or the restriction was reasonable. The only question we face today is whether it is said enough to make it a plausible case, not whether it will probably prevail. Personally, I think once the record is more fully developed, they will not prevail, but they're entitled to their hearing and day in court just like everyone else. When it comes to the government lint, lack of consistency is a problem. It's not necessarily arbitrary and capricious, but it does suggest it, right? If it's without rhyme or reason or obviousness, it's like, well, why are you doing this? It's like, yeah, so that is the end of the case of Cambridge Christian School versus Florida High School Athletic Association. In this case, we learned that two Christian schools want to give a prayer before a game. There is a case on point from the U.S. Supreme Court that says this is improper. However, in prior instances, they have been allowed to pray, including at prior games during this year. The association that administers this, which is a public association run by the government, apparently allowed it in prior instances and did not hear. It's unclear why, however, the government acted the way it did. The government is not allowed to act arbitrarily. Perhaps the government simply made a mistake, but that is not on the record before us. So they went back to trial to figure out what is going on, to figure out what happened, and to figure out if there's discrimination in terms of unequal application of the law. So we will see what happens next once the record is more fully developed.